We are pleased to have Miss Anikashani Harikrishnan, Miss Lo Jie, and Miss Rania Florenjong Modoi. Thank you all for being here today. Now, I would like to invite all of you to take your position on the main call.
The Arbitration Tribunal is now in session. The case before the tribunal, Alpha Limited, Beta Limited, and Gamma Limited against the National Library of India. Today's dispute revolving around the copyrighted issues is between the publishers of the books and the National Library of India. Representing the claimant are Mr. Yong Li Yan and Ms. Devon Xia Yan Wen, and for the respondent, Mr. Nisholdran Ravindran and Ms. Cheryl Ng Wen Xuan. Each representative is allocated 15 minutes to present their submissions, with 2 minutes reserved for the rebuttal, while another 2 minutes for surrebuttal.
Before I proceed, may I confirm if I'm audible?
Yes.
Madam Arbitrator, and members of the tribunal, good afternoon. My name is Devon Xia, and I appear before this tribunal as counsel for the claimants, Alpha, Beta, and Gamma Limited. Together with me is my co-counsel, Mr. Yong, as well as my learned friends, Ms. Cheryl Ng and Mr. Nisholdran Ravindran, for the responders. I'll be addressing the 2 procedural issues, which are, firstly, whether Dr. Daniel should be removed as an arbitrator for the lack of impartiality, and secondly, regarding the bifurcation of proceedings, while my co-counsel will be addressing the substantive issues on whether copyright infringement has occurred and what amounts to fair compensation. We each reserve 15 minutes for our submission and 2 minutes for rebuttals if necessary. Members of the tribunal, impartiality and independence are the cornerstones of every arbitrator and judge alike, and to be in breach of that is a serious matter that should not be taken lightly. Now, the respondents today have appointed Dr. Daniel, a professional with expertise in digital preservation and archival practices. However, justifiable doubts as to her impartiality have arisen. Thus, the claimant's contention is that Dr. Daniel should be removed for the lack of impartiality for 2 reasons. First, the relationship between herself and the respondents, and second, her publications and comments. Now, at this juncture, we would like to lay down the law regarding the standards an arbitrator must always adhere to and uphold. Members of the tribunal, according to Rule 4 of the AIAC Arbitration Rules 2023, these rules provide that an arbitrator can be removed if there are justifiable doubts as to their impartiality. And what amounts to justifiable doubts can be referred to in the 2020 exit case in Iser against Spain. Now, in this case, the arbitrator was removed because of his past professional relationship with one of the testifying experts. A close word.
Counsel,
Yes,
can you clarify what is the persuasive value of this case? Is it persuasive or is it binding on this tribunal?
Madam President, this case is not binding on this tribunal. However, due to it being deliberated by the Exit Tribunal, in which the Exit Tribunal applies the ancestral rules, in which is referred to by the AIAC rules today, that this case is persuasive upon the tribunal today. Now moving on, in that case, the tribunal held that the close working relationship that had formed between the parties would cause a conflict of interest and would have created a perception that the arbitrator might be biased. Therefore, from this case, it can be distilled that the applicable test is whether a reasonable third party would consider that there are reasonable grounds for an appearance of bias. Now in this case today, we say yes for the two reasons. Now we move on to our first submission on her professional relationship.
Is there a difference between apparent bias and actual bias? And if there is, what is the difference between both these biases?
Yes, Madam President, there is a difference here. Appearance of bias is merely how a reasonable third person with the relevant facts and knowledge of the circumstances may conclude that there is a likelihood of the arbitrator being influenced by factors other than the merits of the case. Whereas actual bias is proof and evidence that the arbitrator himself is actually biased. In our case today, the standard here is a mere appearance of bias, which is upheld in the earlier aforementioned case of Iger in Spain, as well as the exit case of Parenco against Ecuador. Now we move on to say that an appearance of bias has been proven due to the relationship between Dr. Daniel and the respondent. Now, if I may direct this esteemed tribunal's attention to the witness statement of Dr. Daniel in page 13, the moot problem. Now, in paragraph 2, when asked what capacity Dr. Daniel has been involved with the respondents, her answer was that she served as a consultant on the Indiva Digital Archives project, providing expertise in the best practices for digitizing and preserving printed materials. Members of the tribunal, the very subject matter of our dispute today is closely correlated with Dr. Daniel's consultancies provided to the National Library or the respondents today.
But Dr. Daniel's relationship with the National Library is as a consultant and it's not related to the ongoing dispute. So why is she appearing biased or demonstrating actual bias?
The actual bias here, Madam Arbitrator, stems from the fact that she has been continually and actively providing advice to the respondents on the matters which concern the very subject matter of our dispute today. Now, this very fact shows that there is a risk of bias on part of Dr. Daniel, which may influence her perception on the issues to be discussed today. Therefore, we say that her past affiliation is cause for justifiable grounds to believe that she may be biased. Members of the tribunal, we further move on to point out the exit case of Constanza against Venezuela, where the court identified a risk of bias due to the arbitrator's past affiliation with one of the parties. Now again, similarly in our case, Dr. Daniel has been affiliated with the respondents in the past for a significant period of time. Now this coupled together with the fact that she had been compensated for her services, as seen in paragraph 6 of her witness statement, shows that from an objective, reasonable third-party point of view, that one would not be able to 100% confidently assert that any judgment she makes is free from an appearance of bias. Now turn on to the second stage of my arguments, in which we say that Dr. Daniel had publicly advocated her position pertaining to the current subject matter of the dispute. And to this, I'd like to direct the tribunal to Exhibit E, the last page of the moot problem, page 16. This, members of the tribunal, shows Dr. Daniel's stance on digitization through a LinkedIn post posted by herself. Now at this point, the respondents may argue that this post was merely academic in nature. However, we disagree. Allow me to dissect the relevant parts of this LinkedIn post to show how this post shows that Dr. Daniel's support is totally in favor of digitization of the books which again goes to the very subject matter of the dispute today. Now, firstly, turning to the first heading under Preserving Our Cultural Heritage. Here, we see that Dr. Danielle has clearly expressed her support for the digitization of books by expressing the full benefits it entails. Next, on the fourth heading, embracing open access models. Here, Dr. Danielle expressed her support for the open access model, which allows information to be made available to readers at no cost. This indicates that Dr. Danielle has not considered the rights of copyright owners, which once again goes to the very subject matter in dispute on copyright and ownership.
Council.
Yes, Madam Chair.
Usually academicians would have their viewpoints on a subject matter. So how does this LinkedIn post differ from a purely academician point of view as compared to raising apparent or actual bias in our case?
Madam Arbitrator, we say that this post is not academic in nature. Firstly, due to the language used in this post, which showcases that this is a matter of personal opinion. Firstly, in the third line of the LinkedIn post, the third line ends with the phrase, "an area close to my heart." And to the very end of the post, it is said that Dr. Danielle is interested in continuing the vital conversations within the community on this matter, which again lays close to her heart, which shows a personal viewpoint on digitization and cultural preservation.
Council, but in the same line that you just referred to in the last line, it also says that I'm eager to hear your thoughts. So does that not show that she's open to having academic discussion on the subject matter itself?
We disagree, Madam Arbitrator. This is because by merely saying that she's interested in hearing thoughts does not detract from the situation or from the fact that she is already clearly in support of these practices. Now, this, coupled with the fact of her past relationship with the respondents, the fact that she has received compensation from her work, continuous work and advice given to the respondents, we say that this shows an appearance of bias. Hence, there are justifiable doubts, and therefore she should be removed as an arbitrator. Now, if there are no further questions on the first issue, we'll move on to the second issue, in which we say that bifurcation should not be allowed. Members of the tribunal, bifurcation refers to the splitting of a proceeding into several separate stages. This is normally done when there is a practical benefit where time and costs can be reduced. Now, in the case of Glencore Finance against Bolivia, the respondents requested for bifurcation to separate the jurisdictional objection and the merits of the case. And there, bifurcation was allowed as the tribunal found that first, the proceedings may be reduced, and second, that it was practical to do so. In our case today, we say that these two considerations have not been fulfilled. Now for this, I would like to direct the tribunal to page 5, paragraph 10 of the Moot Problem. Page 5, paragraph 10. Here, the respondents have requested to bifurcate the proceedings into 3 separate stages. First, to determine whether there is copyright infringement. Second, to determine the applicability of the defense of fair use. And lastly, to calculate preliminary compensation. And we say that bifurcation should not be allowed as it would not bring about practical benefits, as time and cost would not be reduced due to the closely interconnected nature of these issues. Now, members of the tribunal, we say that the first stage would not be applicable. This is because the books are still under copyright protection and have been digitized entirely. Therefore, this amounts to an infringement as it is a complete reproduction of the original book. Therefore, this tribunal would only need to assess the second stage, of whether fair use is applicable. And in the case that this defense fails, the damages that follows. We say that this determination of this issue can be done in a single proceeding, as the defense of fair use is a complete defense, meaning that if it is found to apply to one book, it applies to all the other books, as all books were entirely digitized. And lastly, as for compensation, we say that the statutory damages here can be found in the Ndivya Copyright Act, in which these damages have been predetermined by law, and therefore give sufficient clarity and avoid the need to conduct complex assessments of actual damages or losses. Hence, we say that the entire case can proceed efficiently in one phase rather than having to be split into the liability and damages phases. This is because the tribunal will not need to calculate damages, as only a decision on liability would be required. In short, members of the tribunal, we say that separating these issues would require the tribunal to revisit the same evidence and arguments in two different phases, which may lead to the overlapping and redundant discussions. It does not reduce time and cost of this tribunal, and would instead go against the very crux of arbitration, in which it should be speedy and expedient. Therefore, bifurcation should be denied, as justice delayed is justice denied. We say that the claimant is entitled to protect their hard work from being utilized by the respondent without consent as soon as possible. In conclusion, the claimant submits that firstly, there are justifiable doubts as to Dr. Daniel's impartiality, and hence she should be removed as an arbitrator. And secondly, that bifurcation should not be allowed to delay justice. If there are no further questions from the tribunal, this ends my submission. Thank you.
Madam President, members of the tribunal, good afternoon. My name is Yong Li Ye, and I appear on behalf of the claimant, the book publishers. In the next 15 minutes, I'll be addressing the first substantive issue on copyright infringement and fair use defense, and the second substantive issue on fair compensation. As the second issue is highly contingent upon the establishment of the first issue, I shall allocate more time to address the more contentious first issue. Madam President, members of the tribunal, creativity is the lifeblood of innovation, and copyright is what safeguards its powers. But today, the respondent is draining this lifeblood under the name of digitization. Firstly, under the Biblia Ndivya project, the respondent uploaded the entire copy of the claimant's works for public access, viewing, and downloading. Secondly, the respondent again used the claimant's works to train its Ndivyan AI model, which produces substantially similar texts as the claimant's works. And with that, I turn on to the first substantive issue and submit that the respondent's actions are unlawful for two reasons. First, the respondent infringed the claimant's copyright. And second, the respondent's actions do not amount to fair use. Before turning on to the first submission, the claimant highlights that the Ndivyan copyright law closely mirrors the US Copyrights Act, and therefore, our submission will be primarily relying on the US Copyrights Act and US court cases. Turning on to the first submission on copyright infringement. Members of the tribunal, there is a clear-cut case of copyright infringement for the case at hand. This is because, under Section 501 of the US Copyrights Act, So long as a person violates a copyright owner's exclusive rights as provided under Section 106, he is infringing the copyright of that owner. And applying to the present case, by uploading the claimant's works for public access, and by training the Endeavian AI model to generate similar texts as the claimant's works, the respondent had violated at least two of the claimant's exclusive rights. First, the right to distribute copies of the work to the public, and second, the right to produce derivative works. And therefore, the respondent had
Counsel,
infringed. Yes,
Before you
Madam.
proceed, can you clarify if this books, the selection criteria for this digitalization of this deposit books is that the books are either no longer under copyright protection or are no longer being commercialized? So why is it in dispute today if they're no longer being commercialized?
Well, Madam President, in this regard, we submit that the commercialization merely reflects the current stage of the books. And as stated in the clarification, it does not prevent future re-commercialization of the books. And therefore, despite the books not being commercialized at the current stage, there is a possibility of it being re-commercialized in a future stage, and thereby constituting a copyright infringement.
Counsel, the selection criteria also includes books that are not under the copyright protection. So is that something you are claiming that in your claim as well?
Well, Madam Arbitrator, the claimant is being reasonable, and therefore for those books that are not under copyright protection, there is no copyright infringement, and we are not claiming for those categories. And therefore, upon establishing copyright infringement, I now turn on to the second submission, that the respondent's actions do not constitute fair use. In this regard, under Section 107 of the US Copyrights Act, there are four factors to be considered in determining whether a use of copyrighted works amount to fair use. First, the purpose and character of the work. Second, the nature of the copyrighted work. Third, the amount and substantiality of the portion used. And fourth, the effect on the claimant's potential market value. And at this juncture, the claimant cites the case of Hatchet Book and Internet Archive, which is the latest US Court of Appeal case, just decided 2 months ago. In the words of that court, which I quote in verbatim,
Counsel,
yes,
is
Madam
the
Arbitrator.
decision in the US Court of Appeal binding on our tribunal today?
Well, Madam Arbitrator is not binding. However, if I may refer this tribunal to Moot Clarification number 26. The parties have agreed to apply the domestic laws of Endeavia. And if I may again refer this tribunal to Moot Clarification number 50. If the tribunal is with me, it was clearly stated that the Endeavia Copyright Act closely mirrors the US Copyright Act, and therefore, despite it being a US case, it is highly persuasive on this tribunal. And coming back to the decision of Hatchet Book and Internet Archive, in the words of the US Court of Appeal, which I quote in verbatim, the fourth factor of the effect on the claimant's potential market value is undoubtedly the single most important element. Hence, in the interest of time, I shall submit on the two most important and contentious factors, namely, first, the amount and substantiality of the portion used, and second, the effect on the claimant's potential market value. Addressing firstly on the third factor, on the amount and substantiality of the portion used by the respondent. For the Biblio Endeavia project, if I may refer this tribunal to clarification number 55. If the tribunal is with me, the entire content of the claimant's books was digitized and made accessible to the public. Hence, the respondent not only used a substantial portion, but instead, it lifted the entirety of the claimant's work without a single amendment.
Counsel, but how is it different now for the publishers? Because when it was available in the library, the physical copy, because it was permitted by Section 5 of the NDVI Deposit of Library Material Act, right? So how is it different now that since there were always copies of your book in the NDVI library, which was also accessible by the NDVI public? So how is it different?
Well, Madam President, it is different because, as stated in the record, page 1, paragraph 2, the tribunal is with me. Prior to the digitization project, the Library Material Act only authorizes the respondent to lend 5 copies of the books to the public. But under the current Biblio and Livio digitization project, as stated in the clarifications, page 7, paragraph 23, number 23, my apologies. The Biblio and Livio project adopts an open access model, which does not limit the maximum number of users accessing the same book at the same time, and therefore is substantially different because under the current digitization project, the usage of the claimant's copyright works is excessive and uncontrollable. And turning back to the third factor on amount and substantiality of the portion used. For the Endivian AI model, I refer this tribunal to the record, page 11. At the bottom of that page, it refers to the translated version of the claimant's work. And I invite this tribunal to compare this work with the version generated by the Endivian AI model at the next page of the record. A side-by-side comparison clearly indicates that both texts are substantially similar, with the Endivian AI model merely amending 1 or 2 words in each sentence. Hence, the respondent had used a substantial portion of the claimant's work, and the first factor of fair use is not fulfilled. Turning on to the next factor, on the effect on the claimant's potential market value.
Counsel, may I know if all 4 factors of the fair use has to be satisfied for fair use defense to be applicable?
Well, Madam Arbitrator, it does not have to, it's not conjunctive, and therefore not all of the factors have to be fulfilled. It's the mere factors which the tribunal or court will conjunctively consider them. Yeah. For this factor, according to the case of Hatchet Book, if potential purchasers may opt to acquire the infringing copy instead of the original copy, it substantially affects the claimant's potential market, and accordingly, there is no fair use. And applying to the present case, for the Biblio and Livio project, if I may refer this tribunal to clarification number 5. All books digitized by the respondent can be downloaded and accessed perpetually without any expiration date. This neutralizes and annihilates the claimant's market value because no one would spend the same money purchasing the claimant's works when an exact same copy could be accessed free. And therefore, the fourth factor on potential harm on the market value is also not fulfilled by the respondent. If there's no further queries on the first substantive issue, I now turn on to the second substantive issue on fair compensation.
Counsel,
Madam
before
President.
you proceed, can you assist on how isn't the National Library's digitalization's efforts for public interest? So how does that weigh against the publisher's right for compensation?
Well, Madam President, we have 2 responses. First, the public access to knowledge has to be found a balance between the claimant's copyright rights. The second, even if we merely look at the public interest perspective, looking from a long run, if this type of usage by the respondent is permitted, the authors will not be incentivized to create, and in the future, there will be no innovation in the market. And therefore, merely on a public interest perspective, it is also in line with the claimant's position to see this not fair usage. Turning back to the second substantive issue on fair compensation, the more contentious part of this issue is to assess what amounts to fair compensation. In this regard, the claimant submits that the amount of fair compensation was provided under the statutory damages of Section 504, Paragraph C of the US Copyrights Act. And under this section, the copyright owner may seek an award between $750 to $30,000 for each infringed work. And as held by the 2018 US Court of Appeal case of Smith and Thomas, the specific amount of compensation is at the tribunal's discretion after considering all factual circumstances and applying to the context of the present case. Even though the respondent's usage of the claimant's copyrighted work was excessive and had effectively destroyed the claimant's potential market value, the claimant is willing to act reasonably and exercise considerable restraint on our claim, especially taking into account that the respondent's project was not profit-based and some of the claimant's works might not be re-commercialized in the future. Hence, the claimant seeks the minimum compensation of $750 for each infringed work. The claimant submits that this figure strikes a balance between the respondent's efforts of ensuring public access to knowledge, while at the same time acknowledge the importance of copyright protection for the authors and publishers. Members of the tribunal, Madam President, copyright is an author's shield against any unauthorized usage, and the case at hand is precisely when this shield must be upheld. If I may be of no further assistance to this tribunal, this concludes the claimant's submission. Thank you.
This tribunal is ready. Madam President, members of the tribunal, good afternoon. My name is Cheryl Ng, and alongside me is my co-counsel, Mr. Nishodran Ravindran, and together we appear on behalf of the respondents, the National Library of Indivia. Now, members of the tribunal, today's case is simple. The claimants are essentially arguing that even the remotest of associations and the most ambiguous of representations can and will amount to bias. Now, respectfully, we submit that this is unprecedented, unjustified, and ultimately legally unsound. Now, Madam President, members of the tribunal, as has been laid out, there are 4 issues before this tribunal today. In my submissions, I'll be addressing the first 2 procedural issues concerning first, whether Dr. Danielle Chavon is partial and should be dismissed, and second, whether these proceedings should be bifurcated. While my co-counsel, Mr. Ravindran, will be addressing the remaining 2 substantive issues on copyright infringement, the defense of fair use, and ultimately the relief sought. We reserve 15 minutes each for our submissions and 2 minutes for rebuttal, if necessary. Now, members of the tribunal, turning first to the issue of impartiality. It is the respondent's position that Dr. Danielle Chavon is impartial and should therefore remain as an arbitrator. Now, before turning to the substantives of my argument, members of the tribunal, we would first like to address this tribunal on the threshold that has been put forward by the claimants. While we agree with the claimants that the test or the threshold is the justifiable doubt standard or the reasonable apprehension of bias test, we do not agree with the degree in which the claimants have been applying it. Now, if I could quote the claimants,
it was stated that it cannot be 100% certain that Dr. Siobhan is not biased. Now, this is not the consideration that this tribunal should be taking. In fact, it is on the other end of the spectrum. Referring to the case of Suez and the Argentine Republic, the case stated at paragraph 76 that although actual bias is not required to disqualify an arbitrator, the justifiable doubt standard still places a heavy burden of proof to establish that there is an obvious and high possibility of bias. A high probability of bias, my apologies. A mere possibility is therefore insufficient to disqualify an arbitrator. And hence, while we do not dispute that it is the justifiable doubt standard, we dispute the fact that the claimants, or we dispute the application that the claimants have been running with.
Counsel, is there a difference between the justifiable doubt standard, my apologies, and the apparent bias test?
Now, the apparent bias test would therefore, they are the same standard. What we are saying, or what our submission is, therefore, is that the tribunal needs to determine, based on the case of Suez in Argentina, whether or not there is a high probability of bias.
Counsel, in that regard, then how would you handle the claimant's submission that Dr. Daniel appeared biased and hence satisfies the appearance of bias test?
Now, the claimants have put forth two arguments to say that Dr. Daniel is partial and should be removed. First, they submitted that there are justifiable doubts because she has a past professional relationship with the respondents. And second, they submitted that she had publicly advocated a position, and this is referring to the LinkedIn post at page 16, and I'll be addressing these two in turn. Now, first, on the past professional relationship, we submit, and this is, and before I go into my substantives, for context and for clarification, referring to the clarification document at clarifications 3, 29, and 52, we submit, and it is a fact, that Dr. Daniel is no longer affiliated with the respondents. And this is as opposed to what the claimants have been contending, that she has a continuous relationship with the respondents. Now, this is untrue.
Counsel,
Yes.
how long did Dr. Daniel serve the National Library as a consultant?
She served for 2 years, and this is from January 2020 to January 2022. Now, and this can also be seen in clarifications 3, 29, and 52. Now, on this, or on the past professional relationship, we submit that according to the case of Vivendi in Argentina, that this relationship would not rise to justifiable doubts. Now, in Vivendi, there was a challenge against an arbitrator as he had provided legal advice to one of the parties on an unrelated matter 3 years before he was the arbitrator in that case. Now, the matter in which he had advised was a shareholder dispute within internally in Vivendi. However, the dispute before the tribunal was concerning an investor-state dispute, and hence the tribunal therefore considered that there were no justifiable doubts for 3 reasons. First, that he had disclosed this relationship and therefore was transparent with it. And second, that the issue was unrelated, the issue that he had advised on, and the issue before the tribunal was unrelated. And third, that he was no longer deriving any financial benefit from the relationship. And in this case, all 3 of these considerations are satisfied. In this case, there was full disclosure on part of Dr. Daniel Siobhan, and this can be seen in the witness statement at page 14 of the moot problem. At number 12, if this tribunal is with me. And it can also be seen additionally in clarification number 30. And hence we say that she had disclosed all relevant information, and this shows her commitment to being transparent and her commitment to decide this dispute with integrity. And second, on the past professional relationship, secondly, the past professional relationship was on an entirely different matter. Now, if I could refer this tribunal to page 13 of the moot problem, specifically number 4. And this should be juxtaposed to what is on page 14, number 7. Now, from these clarifications, what it shows is that what she advised this tribunal, my apologies, what she advised the respondent on was the preservation techniques on rare manuscripts. Well, what she has to decide as part of the tribunal as an arbitrator is whether or not there is a copyright infringement on documents that are not rare manuscripts but are documents within the National Library of Ndivya.
Counsel, can you assist on, you mentioned earlier that there was disclosure from Dr. Daniel. However, in clarification, in her witness statement number 7, she has stated that her recommendations focused solely on preservation practices and did not touch upon the legal aspects of copyright. However, if we look at her LinkedIn post, where she was talking about digitalization efforts and preservation practices, wouldn't that then contradict what she has stated in her witness statement? And wouldn't that amount to her not fully disclosing her relationship with National Library?
No, Madam President. If we look at, my apologies, witness statement number 7, it exactly supports our buttresses our point because it shows that she has not formed a determination or has not prejudged the legal aspects of the dispute. Because it shows that although she advised on preservation techniques, 1, she was just a consultant, and we do not know whether the National Library took her advice or not. And 2nd, she did not touch upon the legal aspects of copyright, which means that she has no opinion on the legal aspect of the dispute. Now, with relation to the LinkedIn post, the entirety of the post refers to preservation techniques and has nothing to do with whether or not digitalization of current books or books that are currently in circulation should be available through open access. These are 2 entirely different subject matters that this tribunal has to take into consideration. Now, this is because if rare manuscripts are not preserved, and this would mean that they would essentially disappear off the face of the earth. Now, the goal in determining or preserving rare manuscripts are very different from books that are currently in circulation. And hence, that concludes actually the 2nd point as well, on whether or not she had publicly advocated for a position. Now, in this, just to wrap up that submission, we submit that the LinkedIn post is merely a general post or an academic post on her area of expertise, and therefore does not form an opinion on the legal aspects of today's dispute. Now, having considered the first point on whether Dr. Daniel is impartial, we therefore submit that she is impartial and should remain as an arbitrator.
Sorry, Counsel. Just one question for the first issue. How would you reconcile the LinkedIn post where she said this is an area close to my heart to her alleged impartiality on her side?
If I could refer to the 2 words before that, she says that digital preservation is an area close to my heart. Preservation referring to preserving manuscripts or preserving content that would be lost otherwise. Now, this does not refer to documents that are currently in circulation. Now, turning to the 2nd issue on bifurcation, it is our position that this tribunal should bifurcate the proceedings to these stages as according to the moot problem at page 5, paragraph 10. If I could invite this tribunal with me to page 5, paragraph 10. Now, what the respondent's position is that the proceedings should be bifurcated into these 3 proceedings. Firstly, that there is a copyright infringement. 2nd, to determine that there is whether the fair use defense is applicable. And 3rd, to determine what are the preliminary compensation calculations. Now, to provide some context, bifurcation is essentially separating the proceedings into distinct stages. in which the tribunal would have to determine or make a determination at the end of every stage. Now, our main submission is that it would save cost and time. Now, it would save cost and now to logically bring this tribunal through the argument, if I from the first stage to the second stage, which is to first determine whether or not there is a copyright infringement. If there is no infringement, then there would be no necessity to even determine whether or not the defense applies at all. This is as opposed to what the claimants have contended. The claimants contend that there is an automatic infringement because there was full reproduction. Now, we do not agree with this because there is another aspect to be taken into consideration at the first stage, which is whether or not there was consent, referring to Section 5 of the National Library Act. Now, it is not as what the claimants have contended, that there is an automatic infringement. That is untrue. Now, from the second stage to the third stage, if, let's say, these proceedings were not bifurcated, now this means that the tribunal would have to hear the entirety of the calculations for all 10,000 books that are in dispute. If the proceedings were therefore bifurcated, and if the tribunal determines that the fair use defense, which is a complete defense, applies, there is no necessity to go into the calculations of each and every book that is necessary. And therefore, yes.
But the respondent is proposing to bifurcate the issues into 3 stages, am I right?
Yes.
And wouldn't it be easier for the tribunal if the claims weren't bifurcated? Because isn't there an interconnection between the copyright status and fair use?
Although there is an interrelation, a determination in between those stages would benefit this tribunal, because if there is no infringement, there is no necessity to consider a fair use defense at all, and hence that would save the time and cost of both parties and this tribunal. Now, then we go to the second stage between the fair use defense and the calculation of quantum. Now, the claimant's first speaker and the second speaker seem to contradict themselves. First, they have stated that there is a statutory determination of quantum, but the second speaker has therefore stated that the quantum is a variable one to be determined by this tribunal. And hence, at the end of the day, the tribunal would still need to determine the quantum for each and every book that is put before this tribunal and in dispute. And that would take a massive amount of this tribunal's time that could be saved if these proceedings were bifurcated. I do note that my time has lapsed. Should I be of no further assistance to this tribunal, I therefore end my submissions here. Thank you.
If the tribunal is ready. Madam President, members of the tribunal, good afternoon. My name is Nishunan Ravindran. I'll be acting as the co-counsel for the respondent, the National Library of Nigeria. I'll be addressing the tribunal on the third and fourth issue concerning the issue on copyright infringement, as well as the issue on damages. And I respectfully reserve 15 minutes for my submission. Now, members of the tribunal, knowledge has always been built upon knowledge. In the past, we had physical libraries, and now we have digital libraries. As we move forward, the way we interpret copyright laws should also be in light of these principles. Hence, this brings me to the third issue concerning copyright infringement. Now, in essence, the claimants have alleged that there are 2 copyright infringements. The first is the digitalization project, and second is the AI project. Now, our stance is this: we disagree. And for this, I'll be addressing as to why each of these infringements are just allegations and does not meet the copyright requirement under the Copyright Act. Now, turning then to the first argument on the digitalization of books. The claimant have argued that as the whole books have been digitalized, there is infringement. Now, we disagree. Our response is of two folds. First, there is implied consent. And second, on the alternative, even if there is infringement, this infringement is allowed by the fair use doctrine.
Counsel, where is this implied consent?
Now, as to the implied consent, we will be referring to Section 5 of the National Library and the Library Act, which can be seen on page 1, paragraph 7. Now, on this, we can see first, at paragraph 2 on page 1, where the publishers must deposit the book to the National Library. And then on page 7, we can see the provision that provides the library to do so, the powers to the library. Now, in this provision, there is two powers to the National Library and two things that the National Library can do. The first power of the National Library is that it has the right to reproduce, and this is based on the word of the word copies. And according to Clarification 76, copies includes physical and digital copies. Therefore, the National Library does have the right to reproduction. That will be on Clarification 76.
Counsel, does reproduction
Counsel, if you read on the record, paragraph 2, it says that all publishers have to deposit 5 best copies of books. And in paragraph 7, it specifically says that may place books received under this act or copies thereof. Hence, wouldn't you agree that Section 5 of the Deposit of Library Materials Act does not extend to the digitalization projects and online distribution of these books?
I believe Madam President is referring to the right of communication, whether these books, whether the library has the authority to allow members to access and read these books on a wide scale. Now, we say yes, and for this we rely on the provision itself and the second line for access by members of the public. Now, members of the tribunal, the word access here means that the public are able to access and read the books that was published in the digital format. Now, the bigger question here is, has this been done before by other countries, or is this something of a one-off incident? The answer to this is yes, it has been done by many countries. For example, the signatories of the Berne Convention. The most relevant case will be the case of Australia. Now, in the Australian Libraries Act 1988, Section 108C, capital CA, provides that the library may make digital copies of the book. And few years after that, 12 years after this act was provided, we can see that there was a website that was established, namely the Trove website on the Australian domain. And in this Trove website, there were multiple, if I may quote, 10 million books on the website that has been digitalized based on the books that were deposited. So yes, it has a similar provision, and the word access thereof has been interpreted to mean both the right to communication to the public.
Yes, Counsel, but does that imply that the National Library has the authority to digitalize these books without prior consent of the copyright owner's express consent?
I believe Madam President is relying whether implied consent is sufficient as opposed to express consent.
Correct.
Now, the answer to that is yes, implied consent is sufficient. And for this, we'd like to refer the tribunal again to the UK case of Campbell, the US case of Hatchet and Library case, which was cited by the claimant themselves, the 2024 decision by the Court of Appeal. Now, in that case, the US Court of Appeal has expressly stated that implied consent is sufficient because it will be impractical for the publisher, the library itself, to obtain consent from over 10 million publishers of the book. which is why implied consent is sufficient if there is sufficient acknowledgement to the author, and here we say that there is sufficient acknowledgement to all the authors.
Counsel, for the Australian law on allowing digitization, who can borrow? Is it the same as our case where it is available to anyone with the Endeavour IC?
Yes, in that case, anyone with the Australian identification card can borrow the books. Now, having dealt with the first argument that there is no infringement because of consent, there is implied consent, I now turn to the alternative argument that the infringement is allowed by the defense of the fair use doctrine. Now, for the defense of the fair use doctrine, the claimant have relied on two considerations. First, that all of the books have been uploaded, and second, that there is an effect on the market. Now, members of the tribunal, there is four considerations for fair use doctrine. And if I may repeat once again to the tribunal, the first is that we have to look at the purpose of the usage of the book, whether it is for commercial purpose or whether it is for educational purpose. The second requirement is the nature of the work, whether it is literary work or whether it is work of factual nature. And the third requirement is the harm to the market as expounded by the claimant, and the fourth is the amount that is used. Now, our stance is this. We acknowledge that the whole of the book has been digitalized. So the fourth requirement, the amount used, cites the claimant. But what we are saying here is that the three other requirements, the nature of the book, the purpose, and the potential harm, cites the respondent. And for this, I'll be expounding on each of these three factors. Now, first, on the purpose that is used. Members of the tribunal, it is for the tribunal today to determine whether the book was used for commercial or for educational purpose. If the use was for educational purpose, then it is for public benefit, and therefore it amounts to fair use. And we say that it is used for educational purpose. And for this, I would like to refer to two important facts. First will be on clarification 81 of the Mood clarification. If the tribunal is me on the relevant clarification. Now, here we can see that the National Library is a non-profit entity. What this means is that they're not making any money whatsoever from digitizing the book. They are purely doing it for the public benefit and for the access of the public towards the book. Now, the second important fact will be on clarification 10. Now, on clarification 10, we can see that the users does not have to pay any money to use these books. So we are not making any money from this project.
Counsel, so is it your submission that if it is for education purposes, then the rights of the copyright owners can be sidelined? How would you weigh it against each other? How would you balance it?
We say that there must be a balance between the four factors. So we acknowledge that all the books have been publicized and have been digitalized. However, we have to look at the overall three factors to maintain a balance between these factors. So the fact that it is for public benefit is an important consideration for the tribunal today. Now, turning then to the second requirement on the nature of work use. Now, briefly, the principle is that there is greater protection for books which are of literary nature, and there is less protection for books which are of factual nature. The logic is this. Books of factual nature is important to the propagation of knowledge, and it's important to increase and propagation of knowledge and to increase the overall knowledge in the country. Now, in our case, we can clearly see from clarification 72 that only books of historical and factual significance have been uploaded. So this is not in dispute. Now, the more important consideration that the claimant have heavily relied on is on the third factor, the harm to the market. Now, members of the tribunal, their argument is that as the books can be downloaded, and because of that, they cannot commercialize the books in the future because everyone have access to these books. Now, we disagree. For this, we say that the books are, apologies, we have two arguments to this. The first point to make is that to have potential harm to the market, the books must first be in the market itself. the fact remains that none of these books are commercialized for over 20 years. So if the books are not even in the market, how can it harm the market itself?
Counsel, but do the publishers not reserve the right to re-commercialize their books at any point of time?
Yes, they do reserve the right as long as it is within the protection period. However, if I may refer the tribunal to an important clarification at clarification 47. They have already waived this right when they have placed this book in public domain. Now, members of the tribunal, what this means is that the books are already accessible by every member of the public, and therefore there is no difference between what the library is doing and what they have already done. I see that Madam President has a question.
Counsel, can you assist this tribunal with what do you mean by that it's in public domain? Isn't the public domain that the clarification is referring to, isn't it the 5 books that has been deposited in the National Library itself?
We beg to differ. We say that books that have been digitalized are in public domain in the sense that it is already accessible by everyone through online websites.
Can you?
Counsel, how would you reconcile the copyright owners' right to be incentivized to create, as well as public interest for promoting education purposes?
Now, we say that this balance can be achieved through what the respondent have already done. First, we have conducted market surveys to see whether these books are being commercialized or not. So, the fact remains that the respondent have only uploaded books which are not commercialized and which are in public domain. So, because the books are already in public domain, it is accessible by everyone already. So, the claimant have already waived their rights to control the propagation of the book in public domain. Now, as to the benefit of public research, we say that because the books have not been commercialized for 20 years and is already in public domain, therefore, and because of its historical and educational significance, it lies on the benefit of public to read these books without any constraints. Hence, we say that all 3 factors out of the 4 factors favors the respondent, and therefore we pray to the tribunal to rule the 3rd issue on the respondent's favor. Now, if there are no questions regarding the first argument, I'll now turn to the Biblio Endivia AI project. Now, on the AI project, the claimant argued that there is substantial reproduction of the work in the AI project and the original work. Now, we acknowledge that there is substantial reproduction, but our argument is this: there is no infringement because there is sufficient acknowledgement to the original copyright owners. Now, referring to section 107 of the Copyright Act, the proviso of section 107 of the US Copyright Act, which is in pari materia to the Endivian Copyright Act 2000, we can clearly see here that it states there is no infringement if adequate acknowledgement has been provided to the original author. Now, if I may refer the tribunal to clarification 11, we can see here that any verbatim text that is produced, there is reference to the actual source, and the actual source are also cited. So we have done away with what is required under the proviso, and therefore, as sufficient acknowledgement has been given, we cannot say that we have attempted to copy the work of the respondent, the claimant, when we ourselves have acknowledged that this work is not ours.
Counsel.
I say that my time is about to lapse. May I request the extension of 2 minutes?
Counsel, you have 1 minute.
If I may address Madam President or any questions.
Counsel, can you assist this tribunal? You accepted that the Endivian AI replicates substantial excerpts of the work, right? So does this not potentially diminish the market for these books of these publishers, the claimants?
We say no because the books are already in public domain and none of these translated works are actually stored. If you refer again to clarification 12, all of these works are one-off production based on the data that is inputted into the AI. So if there's a change in data, there's a change in output. Therefore, it does not affect their work. Now, turning then to the 4th issue regarding fair compensation. Our argument is this: The claimant is not even entitled to compensation, and for this, we have 2 points to make. First, the fair use doctrine applies. The fair use doctrine is a complete defense, and therefore, if it is raised successfully, we are not entitled to any damages. And I have cited earlier, we have fulfilled the 3 requirements of the fair use doctrine. I see that my time has elapsed. May I require, if the tribunal requires no further assistance, I conclude my submission. I thank the tribunal for its time and indulgence.
Madam President, members of the tribunal, the claimant has 2 rebuttals to make. First, in relation to the impartiality of Dr. Chiffon, despite the exit case of Iser against Spain, which held that a past professional relationship is sufficient to constitute an apparent bias, the respondent asserts, by relying on Vivendi against Argentina, to argue that collaboration unrelated to the subject matter does not form a bias. But that case is clearly distinguishable. The reason the tribunal in that case held that the professional relationship is unrelated, because what the appointed arbitrator advised is on shareholder dispute, which is an internal matter, while the subject matter being arbitrated is on investor-state dispute, which is an external matter. However, for the case at hand, as stated in the record, page 13, number 4, despite not advising directly related on copyright-related matters, the collaboration centered on preserving historical materials, which basically is what the respondent had been digitizing under the Biblio and Divia project, and therefore, there is a sufficient linkage to prove a bias. Next, turning on to the fair use defense. The respondent relied on the 3 factors, namely it being educational and not commercial, it being factual in nature, and it not potentially harming the market value of the claims, which I will in turn rebut. First, on commercial value. If I may quote the US Court of Appeal case of Hatchet Rules, commerciality is only one part of the first factor inquiry, and the mere fact that a use is educational and not for profit does not insulate it from a finding of infringement. And turning on to the respondent's next assertion that it is factual in nature. In the same clarification number 72, relied on by the respondent, a portion of the books also consists of literary works, which can also include creative works, and therefore, the respondent's assertion that all of the works are factual in nature is an error in fact. And with that, it concludes the claimant's rebuttals. Thank you.
If the tribunal is ready. Madam President, members of the tribunal, 2 points of cert rebuttals. On the first point regarding the impartiality of arbitrator, the claimant continues to assert that the case of Iser and Spain should be used. Now, members of the tribunal, what actually happened in the case was that the arbitrator that was being in dispute was working with the respondent in that case for 2 or 3 cases at the same time. So while he was working with them on 2 or 3 cases at the same time, he was also asked to adjudicate on a case that also involves them. So because of this, there is a clear conflict of interest because they are actively working together at the same time. Therefore, that case cannot be used as a matrix to determine impartiality. Now, turning next to the second argument regarding fair use. The claimant have disputed two facts regarding the commercial value and also the factuality of the books that was used. Now, we acknowledge that there was a mistake regarding the factual nature of the books, but nonetheless, the significant portion of the books were of factual nature, and there was only some of it which was literary nature. The reason is this: because the aim of the Biblio Endivia project is to upload books which are of historical significance, which is why it is more catered towards factual books. Now, nonetheless, the effect of it remains the same. Three factors still remain in the respondent side because of the ultimate consideration, in the words of claimant, the effect on the market. There is no effect on the market whatsoever when the books itself is not being commercialized and when the books are already being in public domain, which everyone can access. And in short, we say that copyright laws should not be viewed as an obstruction to research, but rather it should be used to facilitate the propagation of education. And with that, I end my rebuttals. Thank you.
This marks the end of the arbitration proceeding. Dear judges and voters, you may now leave. Ladies and gentlemen, it's rare to gather such a talented group of mooters for a high-quality moot demonstration. I hope through this session, all of you have gained a clear understanding of what mooting entails and it inspires your interest in this challenging field. Ladies and gentlemen, I would like to invite our esteemed director, Ms. Tam Tian Yi, to present the token of appreciation to our